Hello, boys and girls. Welcome to Commercial Law and Ethics. Wow, we're having snow here in Vermtown today, and I love that beautiful white stuff. What do I have today in my hands to assist with our intellectual endeavors? I have my academic mace here. So I'm going to be looking for correct and right answers today to a myriad of questions I'm going to be posing to you. So you better be ready because you're going to get your money's worth no matter what. Only the intellectual survivors get through my course, okay? All righty. This is an interesting chapter involving secured transactions. So, the title of this course is Commercial Law and Ethics. We've covered a significant amount of ethical subjects, but we'll return to that subject later on in the course. But we're diving today into commercial law. Now, as you recall, my old friend, French philosopher Voltaire, likes to ask the question, before you address me, define your terms. Now, in commercial law, terms are important. We have definitions that need to be mastered by business people engaged in commercial law. And all of you at one time or another are going to be engaging in commercial law. So let us proceed. The best place to start is, so where do we find commercial law? Where do we find commercial law, boys and girls? In the Uniform Commercial Code. Now, you know what that is, right? Is it state law or is it federal law? Talk to me. Very good, Andy. Very good. You got it. It is state law. Now, anytime you see the word uniform in front of a phrase, it means state law, not federal law. Now, why do we have uniform commercial law? I've told you my story way back at the Revolutionary era. That, after the Revolutionary War was over in 1783, for 4 years, these 13 states tried to do business with each other. But after 4 years of all 13 states having their own individual currency and their own different taxation systems, they discovered they couldn't do business with each other. These were all impediments. And so that's actually what led to the Constitutional Convention in 1787. Noticed everybody who went there, from John Adams to Alexander Hamilton to John Jay to even George Washington. Everybody there was a business person. Yes, everybody there was a business person trying to come up with a new system of government where they not only could govern themselves, but also would do business. And that's why you find the Interstate Commerce Clause in the very first Article 1 section of the Constitution. It's a whole bunch of information in there about business. And so business drives not just our economy, but it provides goods and services, employs people. Hey, business is great. That's why we're all in it, right? So it's important to know, where does our business law come from? And so the South Dakota Uniform Commercial Code is identical to the California Commercial Code, which is identical to the Georgia Commercial Code. And on it goes. Uniform. And so what we're learning today is applicable through virtually all 49 states. The 50th state being Louisiana. Their legal system is based on the Code Napoleon, and it gets a little complicated, but they do incorporate some parts of the Uniform Commercial Code. So we begin with asking, so what does Article 9 of the South Dakota Uniform Commercial Code cover? The same identical items as it does in California and Kansas and every place else. It's literally verbatim. So if you look at Article 9 of the Uniform Commercial Code for South Dakota and look at California's, hey, they read the same. That's why we call it uniform, okay? So Article 9, if you will, Chapter 9 of the Uniform Commercial Code deals with personal property, not real property. Now, real property is what, boys and girls? Real estate, right? Real estate. You got it. Real estate. Whereas personal property are other types of things like stocks and bonds, and things of that nature. But we'll talk more about that as we work our way through this. So let me walk through a few definitions that you need to know. So for example, fixtures. What are fixtures? Fixtures, you have them in your homes, you have them in your offices. They are items that used to be personal property, like a lamp, for example, or a ceiling cover of some type, that is now affixed to real estate. So once it is affixed, the item, let's say a projector that we use in our classrooms for PowerPoint, or lights, for example, once they are affixed to the ceiling, they are transformed from fixtures to now what we simply refer to as real estate. Okay? Real estate. So once we attach something, and of course, we're going to see lots of examples as we walk through our session for today. So Article 9 deals with security interests, where Article 2, as we've discussed before, deals with the sale of goods. Now, what is a security interest? All of you have entered into security interests at one time or another. It is simply a legal interest in personal property or fixtures that secures the performance of some obligation. So, for example, a mortgage would be a potential type of interest. But it can also be automobiles. Automobiles, of course, are personal property, right? Or, fixtures that are part of, unless there is a severance agreement. We'll talk about that a little bit later on, Andy, as we walk our way through this. I'm trying to not confuse you all with this material. But that's why these definitions, we're starting with the definitions, so we all understand the basic vernacular of what we're talking about. So, a legal interest in personal property. Let me give you another example. Many of us buy automobiles on loans, right? And so the creditor will take a security interest in accordance with Article 9, and I'll talk more about that in a moment, in our automobile, right? So that if we fail to make payments on time, as we're going to see, they have the legal right to repossess the Article 9 property. So, who is a secured party? It is the party, let's say the bank, the credit union, the creditor who holds the security interest. The credit union or the bank that holds the security interest on your automobile. So what is collateral? What is collateral in business? Collateral is the property, the automobile, the car, the whatever has been purchased based on the loaned money. It's about that property, and we'll talk more about that in just a second. So who is a debtor and who is an obligor? A debtor, of course, is the party that owns the debt and owes a debt to a creditor. The obligor is the party that owes the payment to, as we're going to see, the obligee or the creditor. So the debtor and the obligor can be the same party. So the obligor is the party that has to repay the money or perform some other task. Usually they're one and the same as the debtor frequently, but it could be another party. What's a security agreement? It is a contract. Yep, that K word, remember? Contract in which the debtor provides a security interest to a secured party. What would be an example? Certainly when you purchase an automobile and the debtor agrees to give a security interest in the automobile to the credit union or the bank that is providing the capital for the purchase of the item. So it could be certainly a car purchaser who will sign the security interest to a financing company such as GMAC. But what is default, boys and girls? What is default? Dum da dum dum dum. Default. That's when we fail to pay the money when it is due to the creditor. What happens when we get into default? Ho ho! Here comes repossession. This is when the secured party takes back the collateral because the debtor has breached their contract and has failed to pay money when it is due. Now, what do creditors or obligees, those that are owed the payment on the security interest, how do they perfect their security interest? They go through a series of steps that we'll talk about more in just a moment, involving the protection of the secured party's rights in the collateral against other people other than the debtor. Is it possible that the debtor may try and create a security interest in more than one creditor? That has happened on occasion. And so the way a creditor obligee preserves their legal perfection rights in the collateral is by perfecting it. And as we're going to see, that involves a financing statement and the filing of it in the county recorder's office. So, what is a security agreement or a financing agreement? A financing agreement is a legal document that the secured party files that puts the public on notice that it has a security interest in the collateral. And where do they file that? Routinely, it gets filed in the county recorder's office of the county of residence of the debtor. I think we all know what a record is, but in this day and age, it can be electronic as well as a paper document. What does it mean to authenticate? Nowadays, you can authenticate electronically by encrypting, your identification. But any mark that you make to represent your signature, whether that be an X or printing your name, as well as, of course, writing it out, anything will do as long as you intend it to be the symbol of your consent. So let's talk about types of collateral, okay? You're going to hear the term instrument used in commercial law. What does instrument mean? It could be a bank draft, So for example, when businesses, sell goods overseas, they frequently will have an arrangement with an overseas bank that will permit a party to draft a check against that bank's account that they're holding for the other party. So it can be certainly bank drafts, checks, CDs, notes, stocks, bonds. These are all instruments. Investment property merely refers to securities and related rights, okay? Documents of title. You all have titles to cars, right? And when you want to sell the car, what do? You turn over the title on the back. You authenticate that you are transferring it to another named party. Bills of lading and warehouse receipts can also be documents of title. So it's not uncommon that when people ship goods, that a bill of lading will go with the goods, or sometimes separate from them. And once a party receives the bill of lading, that gives them the legal right of ownership to possess or pick up the goods. Warehouse receipts, after goods have been received at a warehouse, they'll issue a receipt for the goods, and that receipt is given to the party who owns the goods, so that when they surrender the receipt at the warehouse, they get the goods. What's an account? Everybody who's had accounting 201 and 202 better know it's a right to receive payment, right? And of course, what is a deposit account? We all have those. What are commercial tort claims? So, for example, when we have an intellectual property lawsuit, that certainly would involve a personal injury to a company and involve what we simply refer to as a commercial tort claim. So, we've talked about real estate, right? We've talked about personal property. Well, let's talk about intellectual property rights and goodwill and assignments from loan payments and liquor licenses. These all have value, right? These all have value. We call these general intangibles. Now, think about that for a moment. An intangible, intellectual property rights, I think we would agree, much of Microsoft's property is intellectual property. And we would certainly agree, well, it is a form of intangible, right? Goodwill, although those of you who have been involved in accounting should be familiar with goodwill, right? Because you can show goodwill and place value, some value to it on your balance sheet. Assignments from loan payments. Hopefully in your business law course, you've covered assignments. That is where, a intangible is assigned to another party to collect. Liquor licenses, we all know those cost a lot of money, and of course they're of great value, but they can be sold and traded. Alrighty, now let's talk about chattel paper. This is an old English term. What does chattel paper mean? Okay, it is a record, first of all, that serves as an official document indicating an obligor owes money and a secured party has a secured interest in specific goods. So let's use the automobile purchase example. So you have an automobile that is purchased at a dealership, and it is GMAC finances it for the debtor. But the debtor now, of course, becomes the obligor who owes payments to the secured party. And that secured party, GMAC, the creditor, takes out a security interest in the specific goods with the agreement of the obligor debtor, right? So you can take the case of a retailer who sells a consumer good to a buyer, but retains the security interest in the good, and then gives that security interest to a bank as collateral. Goods. What are goods? Under Article 2 of the UCC, these are movable things. They can include fixtures when fixtures are unattached. They can be farm crops once they have been planted and start to grow. They can be referred to, and certainly a security interest in farm crops, farm products, inventory, equipment can all take place. Software that is part of a computer can be considered part of the computer and being a good. Alrighty, now we're starting to get close to our perfection process. Attachment. What does the commercial law term attachment mean? It means, look, attachment takes place when a secured party has taken all the steps necessary to create an enforceable security interest so that the secured party, in the event of default, can collect on the collateral, right? The debtor authenticates the security agreement. That is, they sign it, right? And they usually give it to the secured party, or in the alternative, they can give the secured party control over collateral. So let's take, for example, a loan. You want a loan for $5,000. And the bank says, what do you have for collateral? We're not just going to give you $5,000. We want collateral. Well, you happen to have a valuable stamp collection that is worth, close to $5,000. And so you offer that to the bank. The bank says, fine, give us the stamp collection. So the bank takes physical possession of the stamp collection. And of course, they retain it until such time as the debt is paid off. When the debt is paid off, then of course the security interest will naturally expire in accordance with the financing agreement. And now the debtor will get their stamp collection back. So let's take, for example, we have a secured party that is given value to obtain a security agreement. The debtor certainly has legal rights in the collateral, and there's an exchange, right? There's an exchange. So what do the security interest agreements actually contain? What do they have to have in them in order to be a valid security interest agreement? Well, you need to identify what is the nature of the collateral. So let's take, for example, an automobile. So if you're purchasing an automobile and a credit union or a bank is going to give you, going to finance it for you, the security interest is also going to need the serial number, the VIN number of the automobile. So obviously you can carefully identify the nature of the collateral unit. Your security interest has to state the price, down payment, monthly payments, and interest rate. All common things that need to be there in order for a valid security agreement. What is the basis for the security interest? Usually it's based on the sale of an item to the debtor or the exchange of money. And that, of course, in the event of default, that the secured party has the legal right to repossess the collateral. So assume for the moment your stamp collection at the bank is held there in safekeeping, and you default on your loan to the bank. Well, the bank can then repossess, legally take action with respect to the collateral and sell it in order to have the debt of the debtor extinguished. So if you don't have a security agreement, if a secured party has physical control over the collateral, as in the case of the stamp collection, hey, the secured party is going to have the right to dispose of it legally under the UCC, Article 9, if you have default. Well, is it possible to get a security interest in after acquired property? Interesting question. Think South Dakota agriculture. And so it's not unusual for farmers to go to banks, seek to get a loan, but their crops haven't been planted or sprouted yet. Well, the security interest agreement with the bank will say that the crop is going to be the collateral. And so after it exists, the bank or the creditor automatically has a security interest in it. Now, what happens when we have repossession and the sale of collateral? Well, of course, the debt gets paid first, and if there's anything left over, which is a norm there isn't, but if there is, then of course, whatever the extra is goes back to the debtor. Alrighty, let's talk about the actual process of perfection. what a creditor, what a secured party physically has to do in order to perfect its security interest. Now, what's the whole point of the exercise of perfecting a security interest? The whole point of the exercise is to prevent other parties from laying claim to the collateral. And so this is an official legal way that a creditor places the world on notice that this creditor is first in line with respect to this collateral and that it possesses a security interest in it. So in our own case here, in Clay County, is where a creditor would file a security agreement if it involved a debt or a financing statement that I personally signed because I live here in Clay County. Now, while there's no requirement that a debtor sign a financing statement, you got to have some evidence that a security interest exists. But I think we know as a practical matter, as a norm, financing statements get signed by the debtors. Otherwise, the creditor is going to be very reluctant to loan resources. So the county seat is where the county recorder's office is located. Now, here's an important UCC point. Once the security interest is filed in the county recorder's office, it is effective for 5 years. So the creditor does not have to go back, or the secured party does not have to keep going back to renew anything. Their initial filing is good for 5 years. All right, let's take a look at an actual case to give you an idea of why the details are important when it comes to perfecting and filing in a county recorder's office. So we've got this case involving Corona fruits and veggies versus frozen foods. We've got two creditors who are fighting over the same collateral. But what we have is a debtor who has used the same collateral to get loans from two different creditors, and neither one knowing the other exists until there's a need to collect on the collateral, right? Because of default. So we got Corona, who leases farmland to a strawberry farmer whose name is listed as Armando Munez Juarez on the financing agreement. He signs the lease, Armando Munez, and Corona advances money for payroll and farm production expenses. Corona filed a financing statement claiming a security interest in this strawberry crop after acquired, right? After acquired collateral. 6 months later, Munez contracted with Frozen Foods, a second creditor, to sell his strawberry crop to them. All right, that's Frozen Foods. So Frozen advanced money and filed a financing statement listing the debtor's name as Armando Juarez. Ooh, different, a little bit different name, huh? So by the following year, we got Munez, who's owed Corona 230,000 beans, and Frozen Foods is owed 19,600 beans. When unable to make the payments, that's foreseeable, huh? Corona sought to repossess the farmland with the strawberries, but Frozen also claimed the same collateral. So Corona has filed a financing statement, but it's under the wrong last name and therefore failed to perfect its security interest. The trial court awarded judgment for Frozen Foods, so Corona has appealed. What's our legal question here? Did Corona correctly file its financing statement? So what's the rule of law in this case? So we got the secured party, not the debtor, or involved third parties, that has the duty of ensuring proper filing and indexing of the finance statement. It's the responsibility of the secured party, i.e. the creditor. This did not happen here. Substantial evidence supports the finding that the debtor's last name is Juarez and not Munez. The debtor provided the appellants with a driver's photo ID and other documents with his correct name. But guess what? Corona Foods didn't check the photo ID and made sure that the financing statement that they filed matched. So what is absolutely critical is that the financing statement, the security interest that is filed with the county recorder's office must absolutely, positively reflect the same name that is on the debtor's driver's license. Now, if they're reluctant to give that to you, well, that should put you on notice. Maybe you don't want to do business with this person. So, what does the financing statement contain? Take a look here, boys and girls. All makes sense, right? Okay. If all the parties, oops, wait a minute. Let's try this again. Hold on here. Oops. Let's see here. Show that to me again. Show that to me again. If all the parties have the correct name, is it true that input providers, show me one more, it keeps bouncing back on me. It's usually first in time. That is the first in time to file is the party that is going to be entitled under the UCC to collect on terms of the default. Time is important. So it's not unusual to have debtors go out there and do that. If they helped create value in the collateral, yeah, that's an exception to the rule because, yes. So if they've helped create value, so for example, if you supplied funds for farm equipment to obviously improve and grow the crop, you know, that party that may be second in line might jump to first because they furnished resources that made the collateral possible. That's an exception to the rule. All righty. Good. No. Well, as in the English language, there are exceptions to every rule. So I don't want to kill you with the 35 exceptions to the hearsay rule. So we'll drive on. Okay. So I've already talked about how you can, without a financing agreement, if you take physical possession of the collateral, hey, that's just like a financing statement, right? You got the collateral on your hands. Let's look at the Lane versus Bank one. I think that's an interesting case. We've got two officers of a bank who sought to increase their liquidity by pledging shares of their bank stock in exchange for $2.8 million and $3.25 million respectively. Now, the loan agreement required a loan-to-value ratio of 50%, meaning the shares had to be worth twice the loan as collateral. If there was a reduction in the share price, the debtors under this loan agreement were required to either pay off the loan or to provide additional security. Banks don't want to lose money. So when their security decreases, they want their debtors to make up the difference. So when the stock value suddenly plummeted, the loans exceeded their loan-to-value ratio. When they did not provide additional security, sound like default to you, debtors suggested the bank sell the stock, which they did, but only at less than 10% of its original value. Oh, baby. So the debtors sued the bank, claiming it did not maintain reasonable care of its collateral. The trial court, though, held for the bank. All right, so what's our legal question here? Did the bank exercise reasonable care of the shares? So, as you would imagine, a creditor, a secured party, has an obligation to take care of the collateral, right? That's just common sense. Now, the pledgee here is not liable for a decline. This is the rule of law. is not responsible for a decline in the value of the pledged instruments, even if timely action could have prevented such decline. That is, obviously, in this case, earlier sale. The bank had no duty to its borrower to sell collateral stock of declining value. So, under the Kentucky UCC law, which is the same as everybody else's, a lender has no obligation to sell pledged stock as collateral merely because of a market decline. So that's the responsibility, obviously, of the debtors to work out. So, perfection of consumer goods. What do we have with respect to protection of consumer goods? Well, I think you're going to discover that we're going to wait on that for next week, okay? That this is where I'm going to stop today because I don't want to overload you and drive you nuts with too many terms that you may forget, because especially with your exams coming up, information is important, and that we try and give it to you in small chunks. One of my grandchildren asked me, Grandpa Huck, how do you eat an elephant? And I said, well, Jessica, I don't know. How do you eat an elephant? And she said, one bite at a time. So I think she has a point. So I'm not going to hose you down with more legal terms until next week. But I encourage you to slavishly follow the syllabus as far as bonus point opportunities, discussion opportunities, and certainly stay up with your exams and quizzes. And if you have any questions at all, I strongly recommend that you zip me an email, and I'll always get back with you within 24 hours, except on the weekends when I've got family duties to attend to. Okay, we've done half of chapter 24, security interests. We'll do the next half next week. So stay tuned, boys and girls. Bye-bye.